Hi, I'm Dr. David Branham. Welcome back to another video. Today's video is on the Bill of Rights and the amendments that followed the Bill of Rights. This should help you a lot on the test. A lot of people don't understand that the Bill of Rights was actually the first 10 amendments to the Constitution. And those 10 amendments were to the Constitution that came out of the Constitutional Convention in 1787 in Philadelphia that George Washington was the president of and produced our Constitution. So let's get started. I'll share my screen to get started. And the name of this is the Bill of Rights and the remaining amendments. Today I'm going to go over those first 10 amendments, and in some of them in a lot of detail. A couple others like the third and the seventh, I'm not really going to go over those because those are not really viable amendments anymore. But the other 10 are important. And then I'll go over some of the other 17 amendments that have been done in addition to those first 10, the important ones, so that we can get an idea of what's gone on in the Constitution in the history of the country. Come on, there we go. Sorry about that. Bill of Rights. After the Constitutional Convention, the new Constitution was introduced to the 13 states for the ratification. And fearing the anti-federalist commentary, the anti-federalists did not want this Constitution. They thought the federal government would be far, far too powerful. They would swallow up the various states and take away their independence. So fearing those anti-federalists and their rhetoric about the oppressiveness of the new federal government, James Madison decided to introduce the Bill of Rights. Now, the Bill of Rights were basically 10 amendments to show that the government was very limited. And James Madison has said about the Philadelphia Constitution, if this Constitution doesn't say that the federal government can do it, then it cannot do it. And so our new federal government is going to be very limited. But the people just feared that that wasn't the case. So he introduced these 10 amendments. And these 10 amendments were boundaries on the federal government, saying, okay, the federal government cannot do this. And he didn't think they were necessary because he thought, well, as I said before, the Constitution outlines what we can do, not what we can't do. So he decided to give in just to make sure that this Constitution would go through, get ratified by the states, and that the anti-federalists would not win. And he introduced these 10 new amendments. Actually, they originally were 12. Congress cut them down to 10. The adjustment of adding that Bill of Rights, those first 10 amendments to the Constitution, probably helped get the Constitution ratified by all 13 states. And so I think they're very important. So a list of it, the Bill of Rights, mainly features fundamental freedoms that cannot be intruded upon by the federal government. Now, the First Amendment, most of us know, but you should know these for the test. The First Amendment, there are some things left out of these. These are the things you should remember for the test: freedom of speech, freedom of the press, freedom of religion, and freedom of assembly. Those four in the First Amendment are very, very important. And they have been defined by the courts over time with a various set of cases to show what they really mean. For instance, the freedom of speech. A lot of freedom of speech, people think, well, I can say whatever I want and be fine. Well, in most cases, you can say what you want and be fine from government intervention. A lot of people think they can say whatever they want on their job and not get fired. That's not the case. First Amendment does not protect you from getting fired on your job for what you say. If you call your boss an idiot, he can fire you or she can fire you. So don't do that. The freedom of speech protects you from the government. So if you want to say or state your opinion, you are free from government intervention on that opinion. However, if you extend it, for instance, to creating an action by telling people to go do something, then that speech then turns into action, and you can be sanctioned for that. Freedom of the press. There's been some cases recently, the Fox News case, where when the press purposely has smeared people with lies, they can be liable for that, and it can cost them dearly. So freedom of the press means, yes, you're free to tell the truth and you're free to say what you want in the press, but it does not mean that you can say whatever you want about anybody you want. Freedom of assembly, you're free to assemble and protest, but there are restrictions on that. For instance, you can't block a road. So there are restrictions on all these freedoms. And freedom of religion, well, for many years, freedom of religion meant that you could not practice your religion by praying in the public school. They said that was actually the school creating a state religion. So there's a lot of leeway in how these things, these freedoms are actually determined in the Supreme Court of the United States. Second Amendment, the right to bear arms. That's another one. There are restrictions on the arms that you can bear, but you do have a right to own a gun, especially if you are if you're a regular citizen who has not been charged with any crimes and so forth. You can own a gun, but states have different regulations on these guns, and you don't get to just own one and not have it registered and so forth. You don't get to own the kind of gun you want. For instance, you can't own a bazooka. So there are restrictions on almost all of these freedoms. The Fourth Amendment, protection from illegal search and seizures. This is a very interesting one, but the main thing that comes from this now is that anything obtained illegally by the police in a search or a seizure cannot be used against you in the court of law and has to be returned if it was obtained illegally. So the extent of this often goes to courts where, for instance, can you search a house? Well, if someone opens the door and they see something that is illegal in your door, they can go to that illegal object and confiscate it. And then when they do that, if they see another one, they can do that. They can get that too. So there are these steps that you can take with these, and you have to watch the law very, very closely. For instance, I would highly suggest that if you own a car, that you don't put anything illegal in that car, because if a police officer stops you and sees that in your car, or just has any evidence whatsoever that it's in your car, they can search your car and obtain that legally. So please be very careful with your Fourth Amendment rights. Fifth Amendment, the right to remain silent, the right to a trial by jury, the right to no double jeopardy. You don't have to testify against yourself in court when it comes to crimes, but you can be compelled to testify if you have been given immunity from your crimes. So you only have a right to remain silent to keep yourself from getting convicted yourself. And it doesn't protect you in a civil case either. You can lose your money and be forced to testify on that. So understand that. The double jeopardy rule also, a lot of people don't understand. Double jeopardy pertains to federal cases or state cases, but you can be charged in a state and in federal court for crimes that are very similar if you've broken two different laws. So if you've broken a state law, you can be charged for that. If you've broken a federal law, you can be charged with that, even though it was the same act. So some people think that's double jeopardy. It isn't double jeopardy. For instance, in the Rodney King case several decades ago, where police officers were beating Rodney King, they were charged with assault at the state level, and then they were charged with federal civil rights crimes at the federal level for the same actions. So you have to watch out for the double jeopardy. You cannot have a state crime and a federal crime that are two separate crimes and not get double jeopardy. You can be charged in federal court and state court. The Sixth Amendment, the most important thing about that is your right to counsel. You get a fair trial. You get a right to counsel on every felony case now since Gideon versus Wainwright. We'll go over that in a little while. The Eighth Amendment protects you from cruel and unusual punishment. What that is defined as is in several cases of the courts. Also known as excessive bail. That's in the Eighth Amendment as well. The Ninth Amendment, The Ninth Amendment basically says that rights that aren't listed here doesn't mean that those rights are gone just because they're not listed here. A lot of people admit that there's other rights out, thinks that this means that there are other rights out there that the court should give you. For instance, in Roe versus Wade, the court extended abortion rights on this. And so in most cases, this is dealt with, family courts and so forth. But the reality is that the Ninth Amendment isn't used very much anymore. Matter of fact, it hasn't been used at all for a while. So even though it's an amendment that I think could be very powerful, the courts have decided that it is not really a viable amendment to extend rights to people with it. And that is both, that's been conservative courts and liberal courts. The 10th Amendment, our powers not given to the federal government are reserved for the states and the people, or the people. And so a lot of people who are pro-state government look at this amendment and say and feel like the federal government should restrict itself much more than what it does. And this has been a controversy all through our nation's history. So we'll go over a little bit more on the 10th Amendment to kind of hash out how that has come about. So freedom of speech. Now, I talked about freedom of speech. It started last slide. Now, you do have that protection, that expression of thought and debate, and that cannot be, that is free from government intrusion. You can say what you want if it's your opinion and not worry about being put in jail for it. However, any speech that's used to incite action, this is what a lot of people were getting Donald Trump for on the January 6th controversy, that his speech had actually incited action because he told them to go to the Capitol. The problem is that, in the controversy is that Donald Trump said, I did not tell them to go vandalize the Capitol. I did not tell them to hurt people. I told them to go there and peacefully protest, which actually is exactly what he said. Go over there and peacefully protest. Most people have a problem with the fact that he let it go without really calling off anybody. And that's the biggest problem people have with him. But anytime your speech starts turning into pushing for action, watch out, because you can be arrested for that. If you tell somebody they should murder somebody and a person goes and does that, you are liable for that. And so you can be charged with murder yourself. The other thing is symbolic speech, like wearing armbands or burning the flag in protests. That's been restricted in some cases. For instance, if you want to burn a flag in your backyard in protest and you're not inciting anything, you can do that. You can burn the American flag in the privacy of your own meeting. But if you take it out in the public and start doing it to incite action, then you can be held liable for that. So the symbolic speech is something you have to be very careful with as well. Freedom of a religion. People are free to practice the religion of their choice, but the government cannot establish a religion. And this has had some conflict, especially in schools. In 1962, the court ruled that prayer in school, you just couldn't have prayer in school whatsoever, because it was the establishment of government establishing a religion to do that. But in doing that, you were taking away people's freedom to practice their religion. So there is a conflict in this. Over time, even with those court rulings on prayer in public schools, where the court said, no, you cannot pray in public schools, federal officials were, I'll say, extremely hesitant, or just not going to do it altogether. They weren't going to send any National Guard down to a school and arrest people for praying. It was not politically a viable thing to do. So even though the court had ruled this, in a lot of cases, the executive branch of the government refused to enforce it. And it was completely understandable, because politically they felt like it was okay for people to pray in school, and it was not establishing a government religion. So, talked about the First Amendment, and I talked about the other amendments. I also talked about that Ninth Amendment. The enumeration of certain rights shall not be construed to deny or discourage or disparage others retained by the people. In other words, just because these are the rights that we say in the first 8 amendments doesn't mean other rights aren't there. That's my take on it. This amendment suggests that there are rights that are not only mentioned in the Bill of Rights, but the Ninth Amendment was not used by the Supreme Court until the 60s and 70s when the Warren Court decided, look, we need to expand the Constitution to protect other rights besides, the ones that we had: freedom of speech, freedom of religion, the right to bear arms. We needed extended rights for things not listed, like birth control or abortion. So in the 60s and 70s, they used the Ninth Amendment in the case of Roe versus Wade, 1973, to give women the right to abortion. They used the Ninth Amendment basically saying, look, this Ninth Amendment is something that the founders would have said is a basic right that should be protected by the Constitution that they just didn't put in there. But the amendment could theoretically be used to give freedom of marriage or same-sex marriage or polygamy. And also, you can argue the Ninth Amendment gives you the freedom to marry whoever you want. You can make that argument. However, in Obergefell versus Hodges, which was the same-sex marriage was protected under the 14th Amendment, it didn't use the Ninth Amendment. It just used the 14th Amendment. And consequently, many people say the Ninth Amendment is dead, and maybe it is. Maybe the 14th Amendment, which we'll go over in a minute, is really all you need. You don't need the Ninth Amendment anymore. So the Ninth Amendment has basically been set aside by the Supreme Court. Trying to change pages here. Okay, the 10th Amendment. Powers not delegated to the United States by the Constitution nor prohibited to the states are reserved to the states respectively or the people. Now, this is the amendment that may have got in the Constitution ratified by the 13 states, because it basically said if the Constitution doesn't have it in there, as Madison had said, he said the 10th Amendment isn't needed because we already have it, but he put the 10th Amendment in there, the last amendment. And the purpose was to clear this up. Anything not in this Constitution for the federal government to do is to be done by the states or the people. And so this amendment would suggest that the states have a lot of power, and the power of the federal government is really limited. And I personally think this is what got the Constitution ratified, because there was a lot of reluctance by the states. So the 10th Amendment was added to the Constitution to reinforce this doctrine. But 30 years after the Constitution, these amendments went through, we had the case of McCulloch versus Maryland. And then Chief Justice John Marshall was the third Chief Justice of the Supreme Court. And when he got in, he decided, I'm going to make the Supreme Court a very viable court. And then after that, I'm going to make the federal government very, very strong by my interpretation of the Constitution. So when Marshall did McCulloch versus Maryland, he wrote the opinion in the case, which was a case where the state of Maryland was trying to tax the National Bank. And he basically said, no, the National Bank is a constitutional right of the federal government to make, and the states, because the Constitution said that is a duty of the federal government, the states cannot intervene on that by taxing it. That was the main ruling in McCulloch versus Maryland. But there, Chief Justice John Marshall made light of the 10th Amendment, saying it was created to calm the masses and did not use the word expressly. So in the Constitution, those duties are expressly the duties of, for instance, the duties of Congress, the right to coin money and so forth. Those are express duties of Congress. But he said the 10th Amendment doesn't use that word. So it doesn't mean that, the federal government only has the right to do those things expressed specifically in the Constitution. He says, look, the necessary and proper clause, which says we can do anything necessary and proper to carry out these duties, actually gives the federal government wide latitude to do whatever they want, because all they have to do is connect it to one of those duties, the right to form a Navy. I mean, we can start a national bank because we need it to form a Navy, and we can tax because we need that, and so forth. It gives the federal government a very extensive amount of power. And so John Marshall said the necessary and proper clause allows the federal government to do that. So the 10th Amendment is actually very weak by his interpretation. And so 30 years after the 10th Amendment was put in to calm the masses, the worst nightmare came for those who were pro-state rights. State rights were pretty much gone after that, because Marshall had extended the power of the federal government so much. Now, it doesn't mean that states don't have anything to do. They have clear things that they do that are outside the purview of the federal government. They run elections. States do schools. They're for public. They're the ones that do public education, and so forth. But the power of the federal government was very extensive after McCulloch versus Maryland. Then we have the Civil War amendments. These are the Reconstruction amendments. I'm having a hard time seeing my screen on this. Okay, these are the 13th, the 14th, and the 15th amendments to the Constitution. Now, these were set. The 13th and the 15th amendment were placed in the Constitution because the Constitution needed to make plain statements on facts. Did they need to be there? They didn't need to be there technically if the 14th Amendment was there. There was no reason for them to be there except that they want to state loud and clear, one, that slavery's over. There is no more slavery. The 13th Amendment abolished slavery. The 15th Amendment said the right to vote, you have that regardless of your race. That was there. And those were statements that had to be made in the post-Reconstruction era. So those two amendments are there. I don't say so much for window dressing, but to send a message. But the most important one was the 14th Amendment, because the 14th Amendment gave you everybody due process under the law and equal protection under the law. In everything, they had that. So you don't get to get locked up and put in jail without nothing happening. You have to be charged. You have to be told what your charges are. You have to have a right to a quick and speedy trial. You don't get to be locked up no matter what. And it doesn't matter who you are. It doesn't matter what the color of your skin is, what your gender is. It doesn't matter who you are. The one exception is if you're a non-citizen, you don't actually get this due process clause. This is limited to citizens, although we haven't always limited it to just citizens, but you do have this due process clause for all people, and that they all get that protection. And so the 13th and 15th, there's no reason for them with that there, except for, as I said, to send that message. Okay, and this guarantees that all persons will have fair procedures, regardless of race. So the 14th Amendment, you always see the 14th Amendment in states' rights cases in the federal court, because it's the 14th Amendment that actually creates this country where all government has to be bound by due process. And we're not, and as well, after the 14th Amendment, the court declared we're not bound by the Bill of Rights. Let me start over on that. The 14th Amendment shows that the states are now bound by the Bill of Rights. Before the 14th Amendment, they weren't bound by Bill of Rights. So what happened was in the 14th Amendment originally went to the court in Algier versus Louisiana, and that said that the due process of the 14th Amendment provided substantive due process. Now, substantive due process are rulings that begin incorporation of these Bill of Rights freedoms on to the states and the local governments. So before the substantive due process in 1897, the states didn't have to abide by the Bill of Rights. Only the federal government had to abide by them. So states could limit your free speech. States could limit the press. In most state constitutions, they had it where those Bill of Rights freedoms were there for all people in states. But until this substantive due process come along, you could not apply the federal constitution to the states. So after this 1897 case, where they ruled that substantive due process was there, then they started incorporating slowly but surely Bill of Rights freedoms onto the states. For instance, in Gitlow versus New York, they incorporated the freedom of speech of the Bill of Rights onto the states. So no state could violate First Amendment freedom of speech after Gitlow versus New York. Mapp versus Ohio, a classic case where police went in and basically stormed this lady's house, arrested her, and they stormed without probable cause. When they went into the house, she asked for the search warrant. They stuffed a piece of paper. They give her a piece of paper. She stuffed it down her shirt, and all it was a piece of paper. They had no search warrant, and they confiscated a lot of evidence, including pictures of her children in the bathtub. And so they had nothing in the confiscation except those pictures, and they ended up charging her with child pornography because she had pictures of her children in a bathtub. That brought the case of Mapp versus Ohio to Supreme Court, and Supreme Court ruled in 1961 that all Fourth Amendment search and seizures that were done illegally or without probable cause, all evidence from those seizures would automatically be thrown out. And so now the states had to get search warrants. The states had to abide by probable cause to do searches, and the states had to re-educate themselves on how they police. The same thing happened in Miranda versus Arizona when Fifth Amendment rights to remain silent became embedded in all the states. Before this 1966 case, people would be interrogated for hours and hours, lied to and so forth, until they got the confession they wanted. And a lot of people confessed to crimes they didn't do just to end the torture. So now, when you get arrested, you get your Miranda rights. That's where it comes from, Miranda versus Arizona, where you have the right to remain silent. You have the right to an attorney. If you don't have an attorney, one will be appointed for you. And so you have those civil rights sitting there, and you're told about them. And if you refuse to talk, which I would always suggest you do until a lawyer's present, anything you say cannot be used against you. And Gideon versus Wainwright, the Sixth Amendment right to counsel in all felony cases must be adhered to by the states. So now if you don't have counsel in state court, you get that lawyer there too. Used to, it was only federal court. If you're in a felony case, you get the right to counsel. Even if you can't pay for it, it has to be provided for you. And then finally, the last one I want to go over is McDonald versus the City of Chicago, which actually incorporated the Second Amendment Bill of Rights in 2010 onto the states. So there has to be some level of the right to bear arms in every city and state in the United States. It is a constitutional right. Now, the 14th Amendment, equal protection of civil rights issues, also deals with, when we talk about civil rights, as you saw from earlier readings, civil rights deal with equal treatment under the law. So the first case, the biggest case in history on civil rights, is the Brown versus Board of Education of Topeka, Kansas case, where the court ruled 9-0. It was a 9-0 vote. All 9 justices said that segregation of public schools was unconstitutional. That reversed the Plessy versus Ferguson decision in 1896. And Plessy was not schools, it was railroad cars, where they had segregated railroad cars. So it was, it was a situation where somebody wanted to sit in a seat that they weren't assigned to because of their race. Plessy versus Ferguson basically said, look, if the seats are equal, you can separate them. That's equal treatment. Brown versus Board of Education, 58 years later, in 1954, overturned Plessy versus Ferguson and said schools cannot be segregated. You can no longer segregate your schools. So all over the country, we disintegrated school maps and created new school maps all around the country, where we had integrated schools in every school district that could have integrated schools. It was quite traumatic for a lot of students, because in most cases it was the minority students who ended up getting bused off a long ways to schools. A lot of times, like I was from the Aldine district. In the Aldine district, when they finally did desegregation, which was in 1978, when they finally desegregated Aldine schools, I went to the only integrated school in the Aldine district. I went to MacArthur High School. It was the only integrated school in the whole district. Aldine, Eisenhower, Carver, they were all segregated, where Carver had nothing but African American students, Aldine and Eisenhower had nothing but white students. After I graduated in 1978, they redrew the maps for Eisenhower, Aldine. They basically closed down Carver, created a new high school called Nimitz High School on the far north side, and they integrated all the high schools in 1979 or fall of 1978. That's when they integrated all the high schools in Aldine. It took them 24 years to do that. It took about a quarter of a century for after the ruling to get the schools desegregated. Fortunately, I went to the integrated school, the MacArthur High School, which had a high percentage of African American students and a high percentage of Hispanic students. So I got to be educated in an integrated school. The other schools during that time period, a lot of people were not educated in integrated schools. They didn't know anything about anybody else but besides people of their skin color. So they lost a lot on their education in the process. So Brown versus Board of Education was the most important case in history of civil rights legislation or civil rights cases, because it basically said separate but equal is really not equal. And that's true. There's no such thing as separate but equal. So they integrated schools. Unfortunately, after we integrated all the schools around 1980, 1985, they were completely integrated. We started out resegregating schools. A lot of school districts had now resegregated their high schools. If you look at Houston ISD, you have your African American schools, you have Yates, you have Kashmir, you have your Hispanic schools like Furr and Reagan and Sam Houston. And you don't have very many white students, but they basically are in the three schools: Lamar, Bel Air, Westside. They have basically reintegrated their schools. Spring Branch School District, same thing, putting all the Hispanic school students in Northbrook and Spring Woods, and putting all the white students in Stratford and Memorial. And there are some exceptions to all those, but for the most part, we have resegregated our schools. So even though Brown versus Board of Education ended segregation of schools, once we ended segregation, we started resegregating. And it's something that it seems like everybody just seems to want segregated schools, or way too many people want segregated schools, not everybody. So, white parents want their kids in white schools, Hispanic parents want their kids in Hispanic schools, African American parents want their kids in African American schools, and there's very few exceptions to that rule. The other case where civil rights was very important, those cases were in redistricting cases where they draw political districts from Congress. And so what happened was in a lot of cases, over time, up until 1960, they drew districts that were very lopsided in population. The biggest example was Cook County. Well, Cook County is where Chicago was. Cook County Congressional District had 900,000 voters in it. And then they had several in Illinois that only had about 100,000 voters in them. So you can see the unfairness of it. If you lived in Cook County, you were severely underrepresented in Congress because your district was so big and you only elected one representative. If you lived in the southern part of Illinois, you had a lot of rural districts with 100,000, maybe a little more than 100,000 people in them. Their representation was a lot better than anybody in Chicago, in Cook County. So Baker versus Carr and Reynolds versus Sims, those malapportionment cases basically said you have to have districts about the same size. Now, they don't have to be exactly the same size, except in Congress, where later Westbury versus Sanders said, make them exactly the same size in Congress. But state and local, you have plus or minus 5%. You don't have to have them exactly the same size, but they do have to be fairly equal now. And then there was the case of Shaw versus Reno that was followed by Bush versus Vera. And these cases basically dealt with apportioned districts where they were equal in size. But what you would do is basically gerrymander these districts, where you would draw lines where certain people were in one district and certain people were in others. And this basically created election outcomes before you even finished the redistricting. And so what would happen often is that they would pack African Americans all into one district and then leave a lot of other districts for the white voters. That was the original thing that they did. And then the court, another thing that they did was they would put just a small portion of African Americans in every district and make them all white majorities. So all whites would be elected from every congressional seat because African Americans did not have a majority district for themselves. So when the idea come that, okay, we're going to make a minority majority district, a lot of African American voters love that because all of a sudden they got to elect a person that was like them. And so we've had those minority majority districts ever since the 1970s and 1980s, where we create districts where minority voters can elect a person of their choice. Now, it doesn't have to be a person of the same skin color, just a person of their choice. So in most cases, that is a person of the same skin color, but sometimes not. So we had a lot of those districts. The thing is, Republicans love those districts because you packed a lot of Democrats into 3 or 4 districts, and that left you with the ability to draw a whole bunch of Republican majority districts everywhere else. So one time the state of Georgia, for instance, which had about 50-50 Democrat and Republican, they had 3 African-American Democrats elected to Congress, and they had 7 Republican whites elected to Congress. So we had a 7-3 majority in Georgia among Republicans, even though the state was about 50-50, because they packed the African Americans all into 3 districts. So you can imagine the white Democrats really didn't like this at all. And so, and this is troublesome because you have a lot of African Americans saying, no, we want to keep our African American district. And you have a lot of whites going, yeah, we like it the way that is too. But in the end, the Republicans end up getting a big majority. So Shaw versus Reno basically said, okay, you can't just use race in drawing a district. They would actually connect the dots across the state and look like Rorschach tests, those psychology tests, and create an African-American district and then wrap a bunch of white districts around them. Shaw versus Reno said you can't use only race. And then Bush versus Vera said there are other factors involved in redistricting besides race. So any district drawn just completely with race in mind is unconstitutional. I mean, there are things like neighborhoods and policy interests that people grouped together have, and they deserve to come together in one district and have that representation. So Shaw versus Reno and Bush versus Vera ended race as the sole factor in redistricting. Didn't stop us from looking at race because we still have our African-American majority districts. We have our Hispanic majority districts, but we can't only look at race when redistricting. We have to look at other factors. Like we can't divide apartment buildings in half and have, one side and one the driveway in one district and one side of the other side of the driveway in another district. You have to have other things in mind when you draw the districts. So that's where we are with 14th Amendment equal protection civil rights laws as far as the 14th Amendment rights. We have some other important amendments that I just want to mention since the 15th Amendment. The 17th Amendment, that was in 1913. So we can see we only had 2 amendments in 50 years up to 1913. The 17th Amendment said that the people get to directly elect their senators. As you remember from the original Constitution, senators were elected by state legislators because they represented states. The 17th Amendment changed that, said no, the voters get to elect their senators. The senators belong to the people. So know that one. Famous one, 19th Amendment in 1920. The 19th Amendment in 1920. Women the right to vote. Now, women did vote before that, but only in certain areas, and it had to be state law. After the 19th Amendment, women got to vote. I mean, it's crazy when you think about it, that all the racial laws allowing all races to vote actually occurred over a half century before women got the right to vote. It's amazing how long this was delayed, and it's hard for us to understand because we didn't live through it. And we were born well after that, and we my grandmother always had the right to vote. My grandmother did. So You know, the women's suffrage movement, it was very famous and very important, but I mean, I don't think we see it as important as it really was. So the 19th Amendment gave women the right to vote. 22nd Amendment started term limits for presidents. You notice that was in 1951. Before that, presidents can run for as many terms as they wanted. They didn't have to wait for 8. The reason why presidents did wait for 8, though, is because when George Washington ended his presidency after 8 years, he said 8 years is enough. Presidents need to step aside after 8 years. So that occurred for about 150 years after Washington. No person went for that 3rd term. 2 terms and you were out. You conceded the presidency to somebody else. But then Franklin Roosevelt was elected. Franklin Roosevelt was a polio victim. He was disabled while he was in office. It's very difficult for him to be president, but he was president during a very important time. He won the election handily in the first 2 elections. And when it come time for him to step down, he decided to run for a 3rd term. And he ran for that 3rd term and he won election by a landslide. And so he decided to run for a 4th term. Well, a 4th term was too much. He only got about 3 months into it, and then he died of a hemorrhage. People thought they had pushed him into the grave, and it would be better for presidents to limit themselves to 8 years. So the 1951, I mean, Roosevelt had passed away in 1945. The 1951 term limits for presidents began. Now presidents are basically minimal president can serve is 10 years. If you enter office with 3 years left, you get to serve those 3 and then 4 more, and that's it. You can't go for a 2nd term if you've already done 7. You're limited to 10 years. So that's basically what the 22nd Amendment does. It says it limits you to 2 terms or 10 years, which means 10 years. You can, after 10 years, or if your term is going to extend past 10 years, you can't run again. So Lyndon Johnson, when he was president, Kennedy was killed in 1963. He only had about 14 months left in his term when he was killed. So Johnson was able to run for 2 more terms if he chose to. He chose not to. So this also applies to people like Donald Trump, who lost the election and wanted to run again. That happened before with Grover Cleveland. He lost an election, ran again against the same opponent 4 years later, and won the presidency again. So he's actually the 22nd and the 24th president. So when Donald Trump decided to run again in the 2024 election, it was okay. He had 1 more term left to go because he had not completed his 10 years. The 23rd Amendment gave Washington, D.C. 3 electoral votes, and only 3 electoral votes. It doesn't matter how big Washington, D.C. gets. It only has 3. And the reason why is because Washington, D.C. had no presidential electoral votes because it had no members of Congress. It has no senators. So it always had no votes when it comes to the presidency. In 1961, they decided that was incorrect. It shouldn't be that way. So they allow Washington, D.C. residents to elect a president. And finally, the 26th Amendment, which is in 1971, which is a direct response to the Vietnam War. 18-year-olds were given the right to vote in 1971. And the main logic behind this was that we had been sending 18-year-olds off to Vietnam to fight a war for us. And our voting age limit was 21. So we were sending people off with rifles to fight wars with us who didn't even have the right to vote. So the hypocrisy was clearly there. So the 26th Amendment was passed to allow 18-year-olds the right to vote. I hope that helps you on your test. I appreciate you listening today. And I hope this video helps you. If you need any help, be sure and contact me. Shoot me an email. Happy to talk to you by Zoom or phone, or just by email. It's up to you. Have a great day. And I will see you next time. If I can find this end over here. There we go.